Welcome back to This Is Live, the Sunday talk show here on the Arise News channel. The independent investigative panel on the alleged corruption, abuse of power, torture, cruel, inhumane, and degrading treatment against the Nigerian Correctional Service has submitted its findings to the Minister of Interior, Olubunmi Tunji-Ojo. The interim report of the panel focuses on the findings in relation to investigation into the case of Idris Okuneye, widely known as Bobrisky, and to verify if he served his sentence in any of the Nigerian Correctional Services correctional facilities. For a more comprehensive analysis of that report, I'm now being joined by Dr. Uju Agomoh, who is Executive Director, Prisoners Rehabilitation and Welfare Action, as well as Dr. Ike Ezeugo, a digital forensic expert, crime and social impact researcher. Great to have the two of you on This Is Live. Thank you very much for joining me.
Thank you.
Thank you very much.
Okay, very quickly, let me start first with Dr. Uju Agomoh. Now, the part of the Phase 1 report, as it is otherwise titled, by your committee, set up by Minister Olubunmi Ojo, is about Bobrisky. Whether or not he spent 6 months in a correctional facility in the right place, and whether or not he enjoyed VIP treatment, showing that in this society, certain persons are above the law. What did you find in that regard?
Thank you very much, Ruben. The panel found that from all of the evidence that were before it, including, of course, reports, records, files, interviews of both the inmates and correctional staff, we found thus far that he spent time in custody. And of course, there were instances of him being moved from one custodial center to another. The details I can give you, we can give you that later if that is an information you require. So what we found is that he actually spent time in custodial center, specifically in the medium security custodial center Kirikiri from 12th of April. By then, on the 22nd of April 2024, he was moved from the medium security custodial center to the maximum security custodial center. Recall that he had been sent to Ikoyi custodial center. So whilst he got to Ikoyi, then that movement happened. However, the panel also found that there were instances of some privileges that he also enjoyed while in the facilities, and those are part of the things that were actually found.
Well, look, Dr. Agomoh, let's be very straightforward. Did Bobrisky enjoy VIP treatment? Like having access to phones, like having access to internet, like enjoying special services, and it is standard practice in the justice administration system. What complaints did your panel receive from the public? Because the public thought Bobrisky just went to spend time in a 5-star hotel.
Okay, there are 3 things that you have said, and I recall that there's also one aspect of your earlier question that I think I need to clarify. You asked whether he spent 6 months in custody. He didn't spend 6 months in custody because every time that somebody is sentenced, there is almost like an automatic 1/3 remission, which means automatically when you say 1 year, it's not actually one prison year or custodial sentence year. So he spent the time that is, although through that time, at least from the evidence that we had, through that period in custody. So that is the first established fact. The second part, which is also what I responded earlier, and which was also included in the executive summary and in the main report that we circulated, and I believe that the minister also had that circulated to the public, that there were preferential treatment. We listed all of the preferential treatment that we observed both in the medium security custodial center and the preferential treatment that we observed in the maximum security facility. in Kirikiri. And those, the information we had, those of course included, single cells. He was in single cell in both facilities. We had evidence in terms of access to television, access to fridge, access to humidifier, which was explained to us that it was because of his special condition in terms of the particular medication he was using. And then also there were also emails that were attached to him. Now, in terms of whether he had access to phone, the panel strongly believed that it had been the case. And the reason why the panel believes so is because within the maximum custodial facility, the room where he was staying while he was there was padded. But it is part of what we want to deepen in terms of the second phase of our investigation, to do two things. One, to find out whether the kind of preferential treatment that he enjoyed, whether it was because of corrupt practices or whether money exchange hands, or because of the peculiar case. As you know, there are peculiar circumstances in terms of his physique and all of that, and most of that brought a lot of the correctional officers to a situation where they were a little bit worried because they felt that given the way he was looking, it would be not very good to put him in the general population because anything can actually happen. Now, you also asked whether there are other people who benefit from such preferential treatment. And I said yes, because we also observed there are certain cells, which are the VIP cells, both at the medium custodial center and at the maximum custodial center, and to some degree, even at the corridor, not the same kind of facility as the others. And in many custodial centers across the country, that is also something that the panel wants to look more closely into to find out what are the processes that link to this.
Let me go to Dr. Ezeugo. Dr. Ezeugo, there's another section, another paragraph in that your report. The brief that you were given by the Minister of Interior included looking at sharp practices, misconduct within the correctional service. Now, there was a case of Mena, a certain Mena, Abdul Rashid Mena Jr., who was sending money into the private account of a deputy director or controller of correctional services. Now, what did the committee find about that? Is it standard practice for prisoners to be sending money to correctional officers at the level of deputy controller of correctional services? What did your committee find in that regard?
Okay, thank you very much for that question. I want to start by saying that the investigation we did is not just the usual investigation. My expertise brought in the forensics aspect of the investigation, which means that we are not working on sentiments, we are looking at factual evidence. And even when we get the evidence, we weight the evidence to see what value they have and how we can be able to preserve, protect, analyze them, and present them in a manner that is tenable in court. With respect to the case of Abdul Rashid Mena, we visited the correctional facility where he is serving his term, which is Kuje Medium Security Correctional Facility. We interviewed him. We also interviewed the officer in charge, being the person accused of receiving monies from his son's account. We also interviewed other people within the system. We also looked at several other things, including the account information from the bank. We found that truly the officer received money from the son of Abdul Rashid Mena, which we believe, by reason of the standard operating procedures and the law, that he is not supposed to, for whatsoever reason, receive any money into his private account for any person serving term within the system. And yes, there are a few claims, but our interest is not on the claims, but on the substance of the matter. One of the claims is that he claimed that Abdul Rashid Mena actually requested for him to receive that money. But for us, that's not important. What is important is that he as an officer of the Nigerian Correctional Service, should know what is within the boundaries of their standard operating procedures and how to interface. So we found that truly he received the monies, not once, not twice, I think about 3 times.
Okay, Dr. Ezeugo, part of your brief from the Minister
Yes,
of
please.
Interior was to investigate systemic corruption. How widespread is that systemic corruption? How deep? And what did your committee recommend to deal with this systemic corruption which stares all of us in the face?
Okay, in response to that question, it is important to note that the work of the investigative committee is divided into 2 phases. One is to look at the 2 specific issues, which I just mentioned, the case of Bobrisky and then the case of Abdul Rashid Maina, and that was given 2 weeks, but we concluded in 3 weeks because there were some depth that we wanted to get at. The second phase is to look at the systemic issue that you've talked about now, and we have about 3 months to submit the report on that. We have, I think, between 3 months and 12 to work on that, because we're looking at going to the entire correctional service facilities so that we can be able to get sufficient proof to be able to generalize our conclusion. But so far, we found that there are issues within the correctional facilities across the country. Within the 4 we have visited so far, which is the Ikoyi Correctional Facility, the Kirikiri Medium, Kirikiri Maximum, and the Kuje. We found that there are a whole lot of issues that need to be dealt with, but it is not sufficient for us to generalize. The second phase of our work will enable us to do more and then get more evidence, both from the public and also from the correctional facilities. And that second phase is going to involve public hearing, which we are ready for that now. We are calling for people to make submissions from any parts of the country, whether you have been in the correctional service as a staff, or you have been there as an inmate, or you have your persons who have been there, and you see any form of misconduct, corruption, torture, or whatever. We are expecting that in this second phase, we will be able to dig deeper to be able to get sufficient evidence to make a generalized conclusion on that.
Well, Dr. Agomoh, I've had Dr. Ezeugo.
Let me cut in too.
Okay, please go ahead. Hello?
Yeah,
Dr.
I just
Agomoh,
wanted to explain something. Yeah, yes, can you hear me?
Yes,
yeah.
Please go ahead.
Yeah, I wanted to say that, as he correctly mentioned, the second phase, it's about ensuring that we have a more comprehensive overlook. It is also about providing proper recommendations that will have lasting impact. It is important. So that particular phase, and I don't know where you know the mandate of the investigative panel as was given by the Minister of Interior is for 1 full year. Now, we have done the initial phase, as he has mentioned, in terms of submitting on these 2 issues. But the key thing now is to be able to look at what are those systemic issues, what are those processes that opens itself to such violations or to corruption and all of that. We're going to look at issues about food. We're going to look at issues about how children are treated. We're going to look at issues about what happens to women. We're going to look at issues in terms of the commercialization or access to welfare facilities for inmates. We're going to look at issues about how much the population is managed. As a matter of fact, we're going to look at what are the stumbling blocks that makes it difficult for the Nigerian Correctional Service to completely fulfill the provision or implement the provisions that are stipulated in the Nigerian Correctional Nigerian Correctional Service Act of 2019. But in doing that, we are also very, very mindful of the fact that there are key stakeholders that are important in trying to develop some kind of processes that are fully embedded. So we're going to be looking at those stakeholders, including professional associations, including mechanisms that can enable us to have proper oversight across board. So this now includes 3 major activities. One is the call to the general public to submit any kind of complaints that they may have. You know, these two cases we've dealt with, but there may be others. So this call means that from now to the 1st of December, they are free to be able to provide any complaints, written complaints, make that submission. If they have it in hard copies or on courier, they can send it.
Or soft copies.
You know, they can send that to the office of the chairperson of the panel, and the permanent secretary's office, the Ministry of Interior, Old Secretariat, Gariki, Abuja.
Okay.
They can also send
Doctor.
by email. We also have numbers that they can do that. Yeah.
Okay, doctor, I hear both of you.
Yes, go ahead.
Clearly.
I'm trying to answer.
But I want to draw your attention to another issue with
You know, I haven't, Ruben, I was trying to explain something to you. So there are three things I said because it's really important that the general public understand this, because that will make the next phase successful. Okay. The first phase is this thing I told you about them making submissions, because if they don't submit their complaints, it will be difficult to treat it. Now, following that complaint, on the 12th and 13th of December, we will have the first phase of the public hearing on those complaints that they sent. So the first phase will be 12th to the 13th, but that's followed up from the 13th to the 25th of January 2025 will be public hearing. But public hearing becomes the second part of that second phase. But then there is a third part, which is also very important. This is in terms of focusing on thematic issues, key thematic issues like the ones I explained to you. And this would require stakeholders consultations. And this is really important because apart from looking at the problem, we want to look at solutions and how the solutions can be sustainable and who can partner to make sure that that happens across board.
Okay.
Thank you, Ruben.
Thank you, Dr. Agomoh. But let me come back to you, Dr. Ezeugo. Another issue. We already have the established template with regard to the investigation that your committee is doing with Justice Administration within the correctional service system. This other issue that occurred during the week of minors, allegedly, being arraigned and they were collapsing in court and all of that. Now the Attorney General of the Federation and Minister of Justice is saying, oh, well, maybe the charge of treason will be withdrawn. These were young persons who were protesting against bad governance. And then they were kept in custody for 97 days. Now I know that even the National Human Rights Commission has protested to say this looks very bad. What do you think as a social human rights activist?
Okay, in the first place, there are two segments to that. One is the judiciary part of it, because they couldn't have entered the correctional facilities without going through the judiciary. That's one aspect. And then the second aspect is during their stay in the correctional facilities, how were they cared for? Were they put where they should be put? Were they treated the way they should be treated? Were they handled the way they should be handled? Because from what we saw in the video, it does not look like they were treated or handled the way they should be handled. So that is also part of what we'll be looking at in the second phase of this, our work, so that we can be able to find out what exactly is happening, what protocol do they have in the correctional facilities for handling minors or children, and also for women, like Dr. Ju has said earlier, and for men, for different other people. But that we may not be able to give details until we get to this phase and then get more information about it. But in the first place, I think something is wrong, particularly from the judiciary that sentenced them to the correctional facilities, looking at their age and the very offense that was alleged that they committed.
Well, Dr. Agomoh, what do you think of this subject and the likely intervention by the Attorney General of the Federation?
I think this is the... First of all, I think it is important to decry what we have seen and to say this should not ever be allowed to continue. And I want to also bring to your attention that it is not the first we are seeing young persons in places of detention which is not supposed to be where they're supposed to be. Section 35 of the Nigerian Correctional Service Act of 2019 clearly specified the places where young persons are supposed to be kept. But you know, Ruben, we have only 3 postal institutions in the country, the one in Abeokuta, the one in Kakuri, Kaduna, and the one in Ilorin. The one in Enugu is not functioning. And we have remand homes, yes, remand homes in some of the countries, I think about 29 states, many not functioning well, and some states don't even have it. So the problem is that we need to implement that Section 35 to have the proper place. The young offenders are not supposed to be kept in facilities where they can be mixed with persons. Now, why will a police station keep these young persons? Meanwhile, let me also mention that in the same Nigerian Correctional Service Act of 2019, it clearly states this is one of the criteria to refuse to receive somebody in custody if they're underage. So again, the point here is that as a country, we need to be very serious about our commitment. You know, the Child Rights Act is there. We need to really be very serious about this. Recently, we had a research of all of the custodial centers in Nigeria, all of the remand homes in Nigeria, all of the Buster institutions, with the different government agencies working with PRAWA, with the support of the UNICEF. And that report, which was presented by the Minister of Interior, the National Human Rights Commission was involved, Legal Aid Council was involved, National Bureau of Statistics were involved, and all of that, Nigerian Correctional Service were involved. We found that a high number of persons who are in custody, that are young offenders and children and young adults. And what we find out is oftentimes their ages are even exaggerated. So we must be intentional as a country. This is a completely terrible thing to happen, and it's so disgraceful, and this has also gone very viral across the world. Secondly, it's not only about where they need to be kept, which is to be appropriate, it is also about the capacity of law and security agencies and law enforcement agencies, judicial officers, police officers, to be child sensitive in terms of the approach. You know, there are things that cannot really be encouraged. So we need to be able to do that. And this also brings up a lot of matter. How people are charged. I mean, come to think of it. Look at the kind of charges that you see with those children. And the same thing you see in many places. So the so-called Section 35, subsection 5, where you find a situation telling you that when you pick somebody, you should make sure you send the person to court within 24 hours or maximum 48 hours. You see that proviso to that section opens up a whole lot of web. When people are charged for terrorism, of course, you know that 48-hour rule would not apply. So I think that this is really something, maybe this time will make us be a little bit serious, but it's not supposed to be allowed. And meanwhile, there are many others. So it's not just those ones. Yeah.
Okay, before I let both of you go, Dr. Ezeugo, I'll come back to you. But this then is a matter of law, of human rights. Now the ruling by a federal high court in Abuja saying that Rivers State government can no longer access its entitlements under FAC, under Section 162 of the 1999 Constitution. Because of all these issues about local government, who deported, who departed, who did what. Well, is this not an assault on the people of Rivers State? Is this not the court of law overreaching itself? Is this not a case of the court of law imposing hardship on the people of Rivers State in a matter in which they are innocent? I thought, you know, you are a human rights activist. Dr. Agomoh is a lawyer. Just for you to reflect on this subject briefly before we close.
Yes. Speaking from the angle of a human rights activist, I am not a lawyer, but for what we have seen, it is really absurd. It's unexpected. It shows the federal trying to over-exercise their might or use their might against the state. And I think if we go in that way, we are calling for anarchy, in my thinking, because there is no way the state will begin to feel the impact and they will remain happy as part of the federation, one. And apart from that, if also it is clear in the law that they have overstepped their bounds, I'm not sure it is a good example. So I will want to limit myself on that because I feel that, seriously speaking, it is wrong for what they have, for that ruling. And it has a very negative impact on the rights of the people. But those who are more learned in law who will be able to say the legal aspect of it.
Dr. Agomoh? Dr. Agomoh?
What Dr. Agomoh would like to say, what Dr. Agomoh would like to say is that, you know, this whole concept of federalism and truly applying it is key. This whole issue about really respecting democratic principles is key. A lot of things that we do around elections, pre, during, post, requires a lot of review and redressing. I would like to say this, and I would like to say that it is important that the federal government and the state government apply the processes that ought to be applied within the boundaries of what is expected. It is not important for any to overreach, and when the federal tries to overreach, it is something that can lead to anarchy. So having said that, I will also want us to look at this as something that can begin to help us stress our steps in terms of how we approach elections and governance and development and the respect for the true process of federalism. We are not doing well in the country.
On that
I believe
note,
that we should do this. Otherwise, we will lead ourselves to a problematic situation.
On that note, I would like to thank both of you, Dr. Agomoh and Dr. Ezeugo, for joining me on this live, the Sunday talk show today.